A very warm welcome to each one of you present here. Today, I, Kuhu Bajpayee, would like to welcome you all on behalf of the Burnage Law Journal to this workshop on force majeure. So today we have our guest speaker as Mr. Deepto Roy, who is currently serving as a partner at the Shardul, Amarchand and Mangaldas and Company. I hope this entire session will be useful for each one of you who's attending it. Hello, sir. A very warm welcome.
Hi, how are you?
Hello, sir. How are you doing?
Good.
So, may we start the session?
Yes, I just have to figure out a way to put the presentation on. And
Okay, sir. So, should I help you with it?
no, I should be able to manage.
Okay, absolutely fine, sir.
Is this visible to everyone?
Yes, sir, it is. So, we all can see a screen at this point of time.
Sorry, I seem to have gotten disconnected. Hello.
Yes, sir.
All right. So I'm going to start. I think,
So we can see your screen now.
all right.
Yes, sir.
Okay. First of all, thank you, to everyone for giving me the opportunity to sort of share some thoughts. I think as a practitioner of commercial contracts and corporate law in general, we have been spending a fair amount of time considering the impact of the coronavirus epidemic on commercial contracts. Uh, Without sort of spending a lot of time, I think it's fair to say that the kind of impact that we would see from the coronavirus and sort of resultant changes in business, in society, in the way business will be done, as well as sort of the immediate impact of the lockdown, not just in India but across the world. There have been sort of severe disruptions to trade, severe disruptions to business, to way commercial contracts are performed, and and frankly, I mean, from my perspective, it's something that I have never seen. It's unprecedented. It's very difficult sitting here today to talk about what impact it would have on business, commerce, the practice of law, uh, pretty much every aspect of our life. Uh, there are sort of comparative points with the financial crisis of 2008, but what must be the distinction that needs to be made is that the 2008 crisis was, for all intents and purposes, fairly limited. There was no disruption of normal life. Yes, there was a lot of economic impact. There was a lot of wealth that got wiped out. But from an overall perspective, it was ultimately something which had very limited scope. So while it had a profound impact on businesses and the survival of sort of various lines of businesses, it did not affect society the way the coronavirus is doing. Uh, and therefore, I think sort of any discussion around how this crisis, the lockdown, the various international and national measures that are being taken, how that impacts commercial contracts is very important. And I think, just to start off, we'll talk about how the lockdown has been imposed and the government notifications that has led to the lockdown. We will talk about, certain specific concepts of contractual law, which are most important in a situation like this. And in particular, we talk about the law and the contractual effect of force majeure. But I think, before that, let's sort of, discuss for a moment the purpose of a contract. And the purpose of a contract is very clearly to set out, expectations of behavior and rules of behavior between the two contracting parties. And, one of the fundamental principles of contract law is that a contract once entered into must be performed. And the reason why this principle is so fundamental is that if you sort of move away from this, or you allow deviations from this, you effectively sort of agitate against the very the very nature of contract law, the very sanctity of contract, so to speak. uh, Having said that, of course, given that contractual relationships, like everything else, is subject to a variety of factors, there is a necessity to provide for certain what we call excuses to performance, or certain deviations from performance. And one of the most important one, if you look at long-term contracts, and potentially the sort of contracts I deal with mostly, long-term infrastructure contracts or long-term public contracts, is force majeure. And force majeure as a concept is, is sort of a hybrid contractual concept under Indian law. And we are going to talk about in detail about what to do with a force majeure clause, what are the elements that makes it successful or otherwise. And I think the sort of the important takeaway from, sorry, before I continue, what is the format we are going to follow? Are we allowing questions in between? Are we sort of going to stop at some point? How are we doing this?
So we will be allowing all the questions in like last 20 minutes of the session so that
Okay.
it's much more easier for you to explain. Otherwise, there'll be a lot of interruptions.
Sure. So
Yes.
what I would do is, yeah, so let me sort of go through the presentation and then, we'll take questions. Idea is that I'm going to introduce the concepts and talk about some of the legal developments, but I'm hoping that most of, what we discussed today would be through the question and answer. Uh, uh, Coming back to the concept of force majeure, I think force majeure is, as I was saying, it is a bit of a hybrid. It is essentially a creature of contract under Indian law, and what force majeure does is provides an affected party a respite from its contractual obligations. So before sort of going into the legal aspects of force majeure, let's take a step back and discuss what are the various impacts and what are the sort of legal steps that has resulted in the present lockdown, and how that has impacted sort of the very operation of business in this country. As we are sort of now effectively well aware that it was in the second week of March that the World Health Organization declared COVID-19 as a pandemic. It was something that was being talked about for a month and a half before that. But even all of you would recall that even in the second week of March, we were only hearing about COVID in, through the newspapers or through some other form of media. But in on the 11th of March, the World Health Organization came out and declared it as a pandemic, which effectively means that it's an infectious disease which is going to spread to various countries of the world, and which needs a sort of concentrated response from the various countries. As a result of which, and pretty much from that time onwards, we started seeing a host of actions being taken by the government of India as well as the governments across the world. And more importantly, we also started to see, sort of the statistics on infections and recovered patients and deaths, which is now such a part of our life. As a first step, I think for a couple of weeks, what happened was that the Ministry of Health and Family Welfare worked in tandem with the state governments, and there were sort of general advisories of social distancing. The posters, which talked about washing hands and maintaining social distance and wearing masks, sort of sprung out across our cities, and thereafter, I think what happened was I've got a feedback to speak louder. Is this better?
Yes, sir. You're audible. Yes, sir. You're
Okay.
absolutely audible.
It was from the third week of March that we started taking specific steps under the various disaster management statutes that India has. One of the most important one is the Indian Disaster Management Act of 2005. Now, you would recollect that the 2005 Act was actually brought about in the uh, uh, in the aftermath of two significant natural disasters. One was the 2002 Latur earthquake in Gujarat, and the second one was the Orissa floods of 2003-2004. The Disaster Management Act was, in fact, the first comprehensive legislation that dealt with how India's response to disasters would be. And you can see the kind of broad based powers that it gave the government when you see it in action today. That's not really the sort of the scope of the discussion here. But in addition to the Disaster Management Act, there were two other legislations with the central government and the state governments lent on heavily for taking the steps that were taken to counter COVID-19. One was the Epidemic Diseases Act of 1897, which again, sort of gives fairly broad-based powers of, taking steps to shut down, various parts of the country, uh, uh, various parts of the country for public health reasons. And the third one was the sort of the combined effect of the Indian Penal Code of 1860 and the Criminal Procedure Code of 1973, which is where you get your Section 144 orders. Um, On and from March 24th, as we all know, there was a near total lockdown of the country. There were only essential services which were kept out from the ambit of the lockdown. There were sort of specific guidelines issued under the Disaster Management Act uh, by the NDMA. And what it effectively does is that it put the whole country under lockdown. It suspended businesses, industries had to shut down, shops had to shut down, and of course the people had to stay at home. Uh, our sort of analysis as commercial lawyers at this point, sort of leaving aside the human tragedy and the sort of the various other impacts of the lockdown and sort of the sort of the public health efforts that are taking place, uh, is to consider what it does to commercial contracts. And commercial contracts, sort of obviously require performance, and they require performance in certain specific ways. Obviously, if you break down and go into sort of the kind of contracts that you're talking about, then these performances are subtly different. But most of them involve performing of certain acts in certain times. Now that act can be payment of a certain amount of money, for example, payment of a rent for rent of a commercial establishment. It may involve sort of certain actions being taken. For example, under a construction contract, the contractor is obliged to sort of contract to construct a certain structure within a certain period of time. All of this was disrupted by the lockdown. You did not have sort of the staff available to perform actions. You did not have the ability to open your offices. You did not have the ability to generate the cash flows which are required for for the revenues that the companies depended on. And as a result of which, we are going to see a spiraling chain of contractual breaches or contractual non-performance. And today we are going to talk about what are the legal remedies available which allows us to address these contractual issues. So we go straight into force majeure, and we start with a discussion around what is force majeure and how it is defined. And then also in terms of the legal treatment of force majeure and how that sort of plays out in the present scenario. Now, force majeure is a French term. It means superior force or force which is uncontrolled. In a sense, it is sort of similar to the common law concept of act of God. But as we would see in a little while, the force majeure concept is actually significantly wider. Force majeure is not something which is there in common law as a jurisprudence. It developed in sort of under civil laws, and there is sort of evidence that this was there in Roman laws and Roman transactions several hundred years back. But the first sort of codification of force majeure norms was in the Napoleonic Code of the 1800s. Now, what is important to sort of note here is that because common law doesn't have a sort of jurisprudential backing to force majeure, under Indian law, as under most other common law systems, force majeure exists purely as a creature of statute. So what do we mean by that when we say it's a creature of sorry, it's a creature of contract. So what do we mean when we say it's a creature of contract? It effectively means that if you don't have force majeure protection under your contract, you would be hard pressed to and claim relief from a force majeure perspective. You still have certain statutory reliefs, which is which is called the doctrine of frustration or the doctrine of impossibility. But as we would see in as we go through this discussion, those reliefs are actually much harder to sort of get. They have a much higher threshold of proof, and accordingly it is in the interest of any sophisticated commercial party, and I would say even sort of the smaller companies, the smaller corporates, to have force majeure provisions in their contracts. Because what force majeure does is exactly what we said was one of the outliers to the principle of contract or the sanctity of contracts. It excuses the affected party from performance of the contract. And usually that sort of the excuse of performance is on a temporary basis. How does a force majeure then get regulated? Entirely through the terms that you include in the contract. In a contract, you are expected to lay down what are the events that you would consider as as force majeure. You're expected to lay down what is the consequence of that force majeure. You're expected to lay out any exceptions that you consider to the principle of force majeure. And most importantly, you're also expected to lay out the procedure that needs to be followed by an affected party when it comes to force majeure. And this procedure becomes extremely important because unlike where the remedy is statutory in nature, when your remedy is contractual, then the contract can actually regulate the way in which you'll get the merit. Get the relief. So, for example, if your contract says that you will not be able to claim force majeure unless you give notice within a certain period of time, if you fail to give that notice, then you're likely to lose the relief of force majeure. Now, from absolutely contractual perspective, courts have now decided that a force majeure is governed by Section 32 of the Indian Contract Act, which deals with contingent contracts. In simplistic terms, a contingent contract is, effectively lays down a situation, or it lays down an effect of what happens if there is an uncertain future event. Contingent contracts are of various types. There are contingent contracts, for example, which say that upon the occurrence of a certain event, you will have to pay a certain sum of money. There are contingent contracts which says if certain conditions are met, then a transaction will go through. And there are contingent contracts in the nature of force majeure which says that if certain events happen, then performance under the contract is excused. Which is why, sort of the force majeure, to the limited extent that there is statutory regulation of force majeure, it is actually under Section 32 of the Indian Contract Act. The other sort of important procedural, uh, 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 the other important statutory provision that is there under the Contract Act is Section 56. And Section 56 actually talks about the doctrine of impossibility or the doctrine of frustration. And we will go into that in some detail because it's a fairly important legal point. But that covers a scenario where effectively you are entitled to claim whatever relief you want under law for a situation of impossibility which makes the contract impossible to perform or which makes the contract frustrated. The problem with Section 56 relief is that it's an extremely high threshold and it's very difficult to get to a stage where you will be entitled to that Section 56 relief, which is why the standard wisdom that operates today in commercial contracts is that if you have a force majeure contract, you go under that force majeure contract, you go under Section 32 of the Contract Act. If you do not have a force majeure contract, because there is no force majeure protection available outside the contract, you have to invoke Section 56 and you have to prove that the contract was impossible to perform. So let's sort of then talk about frustration of contract and what it entails. As I said, the doctrine of frustration is envisaged under Section 56, which says in sort of, it literally states that an agreement which becomes impossible in itself is void. So what does that mean? It effectively means that I've agreed to perform the contract in a certain way. And the contract is to be performed for a certain purpose. Now, if that purpose is removed, or if it becomes entirely impossible for me to perform the contract in the ways that I've agreed, then the contract becomes impossible to perform. And effectively, what it covers is that a situation where there is an unforeseen event, an event which is not envisaged by the contract, if that event occurs during the performance of the contract, and the impact of that event is to remove the very base of the contract, then it becomes impossible to perform. And I get the relief that is available under Section 56 of the Contract Act, which is that I do not need to perform the contract any longer. The contract stands terminated vis-a-vis my obligations. Now, it's important to note that there are two sort of major English cases on frustration of contract, and they can be very usefully used to show the circumstances under which you would consider a contract to be frustrated. The first one, and you probably would have sort of studied most of both these cases when you did contract law. The first one is the case of Taylor versus Caldwell. In Taylor versus Caldwell, there was an opera house which was supposed to be reserved for certain performances, and the contract related to the conduct of those performances. That opera house burned down, and there was, it was completely destroyed to the extent that you couldn't have any further performances there. It was held that the contract has become impossible to perform because the very purpose for which the contract was entered into, that is performances in the opera house, has now been frustrated. Secondly, there's Krell versus Henry. Again, very famous English case which effectively talked about these rooms which were rent out for people to watch a procession for the king's. I think it was his crowning. The king fell ill, and the procession had to be postponed. And then the question that arose was whether the people who had paid for those rooms or who had reserved those rooms needed to pay for them. And the courts held that no, because the purpose of the contract was to watch the procession, and the rent was being paid so that you could watch the procession. Once the very base of the contract vanished, uh, then you no longer had a situation where the contract needed to be performed. So therefore, under the English contract law, what we see is that first you need an unforeseen event to occur, and second, that unforeseen unforeseen event, should result in the contract becoming impossible to perform. And these two tests need to be met for you to claim impossibility of performance and cause the contract to be frustrated. There are several Indian cases which deals with the doctrine of frustration, and in particular, this is probably not the right place to that, but there are subtle differences between what is the English contractual law doctrine of frustration and the scheme which has been laid down under Section 56 of the Indian Contract Act. And probably the most famous of these cases is Satyabrata Ghosh versus Mungiram Bangur, where three major principles on Section 56, and this is a 1954 Supreme Court case. But those three principles that were laid down in this case are followed till date in commercial contracts, and even as sort of late as 2018, 2019, the Supreme Court has confirmed the sort of the Bangur doctrine of frustration of contract. Now, the three principles that were laid down in Satyabrata Ghosh versus Mungiram Bangur was one, to deal with the nature of frustration under Indian Contract Act, under Indian contract law. And the court held that Section 56 is effectively a complete or exhaustive code to the extent of how frustration will operate in under Indian law. There is nothing outside the corners of Section 56 which can be relied on to claim frustration of contract, which is different from the from the English law of frustration, which allowed certain specific exceptions and additions to the doctrine of frustration outside the statute. What Satyabrata Bose also did was lay down the positive rule that what constitutes a permissible discharge or an acceptable exception to the subsequent performance of the contract, which effectively is what we were talking about when we said that there has to be a supervening impossibility or an unforeseen event that happens later. So that event had to be specifically judged or specifically fitted into the four corners of Section 56. And you couldn't rely on sort of general common sense principles or equity principles in interpreting the effect of that event. It had to necessarily be governed by Section 56. The second principle that Satyabrata Ghosh laid down was that the doctrine in Indian law is of the supervening impossibility or illegality. And when we consider impossible, impossible has to be looked at as a practical concept. So it is not that you have to effectively say that impossible means that there is absolutely no way of performing it. It is not that stringent a standard. It is not impossible which is literal to the extent of saying that there is no way of performing the contract. There may be some extremely onerous ways of performing the contracts, or some extremely sort of, for example, if a contract can be performed in 2 years, it may now be possible to perform it in 20 years. But that is not the purpose when you consider impossibility of performance. So you have to take impossibility from a practical perspective, and then you have to also look at it from the purpose of the contract perspective and the intention of the parties. So again, if the intention of the parties was that a certain delivery or a certain building has to be constructed in 2 years, it's not good enough to then say that this can now be done in 20 years. Because once you have reached a situation where it cannot be done in 2 years and can be only be done in 20 years, you're effectively reached the frustration of the contract. And the third principle that was laid down in Satyavada Ghosh was with respect to the manner in which you interpret impossibility, or in the manner in which you consider a fact situation and you decide whether it is impossible or not. And that effectively requires the court to consider a vast number of circumstances, the belief, knowledge, and intention of the parties, the evidence of the changed circumstances, whether that changed circumstance destroyed the basis of the contract and its underlying object. And it is on the basis of examining all these various factors that a court could finally conclude on whether the contract could be said to be frustrated. It is very important to note when you consider the doctrine of frustration or impossibility that merely because a contract becomes onerous to perform does not mean that it is impossible to perform. So effectively, there has to be a line drawn between onerous to perform and practically impossible to perform. And the moment it is practically impossible to perform, you have the protection under section 56. However, if it is just more difficult, if it's just more expensive, if you just have to take 10 steps more than what you were originally envisaging, none of that amounts to frustration. And that, I think, is the primary difference between the doctrines of frustration and force majeure, in the sense that frustration, being a statutory construct and being a fairly sort of complex situation to establish, actually provides for a very high degree of conviction in the event which leads to the frustration. So if you go back to the Taylor versus Caldwell example and say that the very basis of the contract is destroyed because the site of performance is no longer available for performance, those are situations where the doctrine of frustration can be invoked. However, in a majority of commercial contracts, since performance is or since to establish that performance has become impossible and not merely onerous is extremely difficult, the section 56 relief is very it's less common for people to go for relief under section 56. Some of the situations where section 56 works well, for example, in a situation where there are certain conditions to be met for a contract to be capable of performance, and those conditions are not capable of being met because of the supervening event or situation. In that circumstance, obviously the section 56 relief is available, but for the vast number of commercial contracts, that relief would not be available. The second important point around section 56 is that section 56 results in a termination of the contract. The contractual relationship is no longer existent. What that means is that the only remedy available to you when you claim impossibility of performance is for you to have the contract terminated. You cannot have a situation where you suspend your performance for a few months or till such time as the event goes away, and then let the contract continue. And this may not be to the best interest of the party affected, because the party affected is only looking for a temporary relief in most cases. He is looking at not paying rent for the 3 months in which he doesn't have cash flows due to the lockdown. He's not looking to say that he has a 10-year contract on potentially well negotiated terms, and in the second year of that the lockdown happens and he claims impossibility and the contract falls away. It's not an ideal situation for him. He may not be sort of interested in that, or it may not be something that is to his business interest. I think net, sort of the whole discussion around frustration and force majeure leads to the conclusion that you must have a force majeure clause if you're looking at sort of long-term contracts, if you're looking at contracts which rely on certain uncertain or sort of a variety of other events from happening. You should draft it in. You should draft it in carefully, and it is potentially going to give you far more relief than Section 56 can do, and in less sort of onerous circumstances as well. Essentials and consequences of force majeure, and these are sort of principles that have developed over a period of time, primarily through contract drafting, and but even otherwise through the ways clauses have been interpreted, force majeure clauses have been interpreted. Now, one of the important things to note about a force majeure clause is because it is effectively negating performance, or if it's excusing performance, it is read extremely narrowly. So when a court interprets any contractual provision which excuses a party from performing, whether it's a termination clause, whether it's a limitation of liability clause, or whether it's a force majeure clause, they will read it very, very narrowly. They will interpret the intention of the parties from the very specific wording of the clause. And that's why the wording of force majeure becomes very, very important as well. However, there are some general principles which are there in every single force majeure clause and which are necessary for you to establish that a force majeure has occurred. For one, the occurrence should be beyond the control of the affected party. So it should not be, that the affected party has not paid some, sort of some fee, or has not taken some approval, and as a result, there are government actions which stops him from performing. Those are not force majeure. Those are effectively events within the control of the affected party, which the affected party has not done. So events in breach will not amount to force majeure. Events which take place as a result of the breach by the affected party, either of law or of its own contractual obligations, will not amount to force majeure. The second aspect of sort of the definitions of force majeure is that it must be something that was not reasonably foreseeable. And I think when we did sort of when we studied Act of God, we already had a fair amount of understanding of what is foreseeability from the perspective of making a contract or excusing performance of a contract. And reasonably foreseeable therefore means that in the circumstances of the contract, the occurrence of the event which you are claiming as force majeure was not foreseeable, was not something that you could have predicted. You cannot build a bridge in an earthquake prone area, not take earthquake protection measures, and then claim the earthquake as a force majeure, because you should have foreseen as a reasonable person that the bridge would have been affected by an earthquake if that earthquake happens. You were aware that because of the nature of the area, the earthquake was far more likely to happen, and therefore you will not be able to claim force majeure because your sort of the event for which you're claiming force majeure was actually foreseeable at the time you entered into the contract. Similarly, during the SARS outbreak of 2005, there was a fairly sort of important arbitral award, where it was held that the non-performing party was not excused as a result of force majeure because of the fact that the contract was entered into when the SARS outbreak had already started. So there was some ability for the people drafting the contract to envisage the impact of SARS. And for example, if contracts were entered into in March of 2020 by Indian company or by any company, and they did not include and they claimed COVID-19 spread as force majeure, they would be hard pressed to establish that, because again, they should have been aware of the situation and they should have been able to foresee the kind of impact that it will have. It should, of course, the third important limb of the definition of force majeure is impossibility. For whatever time period the force majeure has to operate, the contract must be impossible to perform. So there is no way in which the contract could be practically performed by the party which is affected by the force majeure. The fourth one is what we call the causal test, which is that the intervening event or the supervening event and the non-performance should be linked. So therefore, it might be a force majeure event. Say, for example, earthquake impacts a certain district in China. But if your factory was not in that district, and if you cannot establish that your factory was closed down as a result of the earthquake, you will not be able to claim force majeure benefit. We talked about the importance of notice, particularly from the perspective that these are all contractual obligations and you would need to have a notice in place. And if there is a notice obligation under the contract, then if you do not comply with that notice obligation, you might lose your claim of force majeure, you might lose the protection that is afforded under the contract. Because as a creature of contract, any procedural aspects which is outlined in the contract are considered to be equally important. And if you do not comply with the procedure procedural guidelines, when invoking force majeure, the chances of you losing that claim are fairly high. And finally, there's this really complex area which is around alternate means of performance. It's not something we can spend. You can actually spend an hour just talking about what is meant by alternate means of performance and what is meant by mitigation of losses under the force majeure contracts. But suffice it to say that alternate means of performance means that if there is an event, or if there is a manner in which the contract can be performed which is not affected by the force majeure. For example, if you are supplying fact XYZ equipment from a factory in China, and that China factory shuts down because of COVID, you will actually need to establish that you are not able to sort of source that equipment from any other part of the world where that equipment is still available, or where the similar force majeure situations do not apply. And in that situation, it becomes extremely difficult for you to establish that you are taking whatever steps you can to ensure that the contract is performed. So alternate means of performance is always going to be a very important factor in deciding force majeure. A majority of the force majeure cases sort of hinge on the fact that whether you had an alternate means of performing the contract, and if you had, then your sort of claim of force majeure is likely to suffer. um, as we have been talking, the drafting of a force majeure clause is of utmost importance, because the entire relief depends on drafting. Like all clauses which excuse performance, I was talking about how it will be narrowly interpreted. So let's take a look at two, sort of illustrative, two examples of where an epidemic has been considered or not considered a force majeure. In Phelps versus District Attorney, Wayne County, it was held that an epidemic was not an act of God that would allow the school district to avoid paying teachers who were ready, willing, and able to teach, but were prohibited from doing so by the school closure. In contrast, the North Dakota Supreme Court in Sandy versus Brooklyn School District held that a school district was excused from paying a driver for his services during the school closure by determining that pandemic was an act of God, and that non-payment, and that non-payment was excused by the force majeure clause. So the other sort of important perspective to be kept in mind while looking at a force majeure is that you need to see whether the definition of force majeure in the contract is limited, or is illustrative or exhaustive. So it may well be that you just give me a second, please. Sorry about that. Yeah. It may well be that your force majeure event list is an exhaustive list, which means that you effectively lay down, uh, you know, 10 or 11 items which you consider as force majeure. So you can consider that as act of God, you can consider natural calamities, you can consider floods, you can consider, sort of government actions, you can consider acts of war, acts of sabotage. These are sort of typical events which you consider as force majeure. Now, if you do that, effectively what happens is that anything which does not follow within those 10 or 11 items is not considered as force majeure, and you will not get any protection, because what you have agreed to is an exhaustive list of force majeure, and you will not then be able to sort of work around it or claim something else as force majeure. The other and sort of more common way of doing this is to have what we call an illustrative list of force majeure items. So you say force majeure means XYZ. It means something which was not foreseeable, which happened after the date of the contract, which has impacted the performance or made the performance of the contract impossible. And then you also say that the list of force majeure items that you provide is including but not limited to, or would include events of similar nature. And that means that even if your event is not specifically defined in the force majeure clause in very specific terms, you will still be entitled to a force majeure protection if you can show that the event which you claim as force majeure is actually of a nature similar to the ones which you have already specified as force majeure. This is where courts would typically apply the principle of adjudicandum generis, where effectively they will look at awards by the company they keep, and effectively then decide whether an incident would fit into the family of words which you have included in the illustration, and whether that then can go into uh, the definition of force majeure. The sphere of control concept is again a very sort of sophisticated but very important concept in the context of force majeure. The sphere of control effectively is used to define whether subcontractors or other people on which a party relies on for performance, whether a force majeure event affecting that party would also allow the main contractor from claiming force majeure. So let me give you an example. For example, if under a construction contract, there's a main contractor, and main contractor X then sort of, the main contractor X then goes on and subcontracts to uh, subcon- yeah. Uh, so the main contractor then subcontracts his, sort of a part of his activities, let's say the supply of a particular material, to a subcontractor Y. Now, what happens is that the force majeure now has affected subcontractor Y. So let's say there's an earthquake in the factory where subcontractor Y is situated, and that has resulted in the factory shutting down, and therefore Y is not able to supply it. Can everyone put yourself on mute, please? Thanks. So effectively, what you do then is that under your contract, you actually don't have a force majeure which is affecting you, and you are the primary party under the contract. However, what it is doing is it's impacting, sort of your subcontractor, and that is when the sphere of control test becomes very important. The question then is that whether the person who is affected by the force majeure event is within a certain party's sphere of control, and if it is, and if if your clause is broad enough to include parties in that sphere of control, then you will still be entitled to force majeure relief. um, I think we have sort of overall talked about the consequences of force majeure. Majorly, these are things that are written down in the contract and are legislated for in the contract. I think this includes things like the right to terminate the contract if the force majeure typically continues for a certain period of time. Whether it allows you to suspend the contract, that is, suspend performance for a specified period, which is usually, sort of the period for which the force majeure operates, and then uh, whatever time is required to recover from that force majeure. Waiver of damages or penalty for non-performance. So whether, if, let's say, for example, going back to that construction contract example, if there was a requirement to complete the construction in 2 years, and it's written in the contract that after 2 years, if you're not able to complete the contract, you will pay me XYZ damages for every day of delay, then sort of the contractor in a situation that we are discussing today should be able to claim force majeure and then argue that those damages are not payable by the contractor. There can be a change in the consideration, so either by means of uh, uh, by means of an increase in the term of the contract or some increased payment under the contract. The consequence, as I said, is sort of heavily dependent on what the contract says. I think, on an overall basis, this provides, to my mind, a fairly sort of broad understanding of what is force majeure. I think we can sort of discuss more of this when we come to the question answers. Uh, I would, before sort of wrapping up, want to talk about one additional sort of provision which is there in commercial contracts, and this is not something that is dealt with in any great detail under contract law, because it's a very specific and a very negotiated provision in most commercial contracts, and that is what we call a change in law. A change in law clause effectively provides protection to a party in case there's a new law that has come after the date of the contract. Now, if you remember that under the Indian Contract Act, if there is a law is passed which makes the contract impossible to perform or which makes the contract illegal, then the contract is terminated and neither party has to perform the contract. The second thing that the Indian Contract Act also says that if you have any contractual provision which looks to override a provision of law, then you will not be able to perform that because it becomes an illegal performance and nobody will be able to enforce that performance against you. However, there's a third set of circumstances which is typically more common in sort of long-term commercial contracts, and that is in relation to a legislation which comes into force after the date of the contract. But that makes it more difficult to perform the contract, or more sort of more expensive to perform the contract, or makes the contract impossible to perform on a temporary basis, or say, let's say, a change in taxes which makes the contract sort of more expensive, or reduces the profit margin of the contract. And the way parties typically deal with it, in particularly in long term contracts, is that they have a change in law clause. A change in law clause effectively says that any legislation, whether it is sort of a new law, whether it is a modification or amendment of an existing law, whether it is the change of interpretation of any law, all of that sort of then goes into the question of change in law relief. And the intention of the change in law sort of provision is to ensure that you are in the same economic position that you would have been if the change in law had not occurred. So, for example, let me give you a sort of a live example. In 2016, the government of India decided that it's going to, sort of overnight stop the usage of 100 and 500 rupee notes, and that was implemented. This is sort of the demonetization situation that affected the country. Now, one of the first places where this impacted was toll roads, because toll roads, obviously collect toll, and they rely a lot on cash because they're mostly looking at freight traffic, trucks and buses where the drivers usually carry cash, and a lot of that legal currency suddenly became infructuous and not usable. So what the government then did was ask toll roads not to collect toll for 21 days, or whatever time period it was thought necessary, for the impact of that legal uh, that enactment of that law, or the governmental action was sort of mitigated, and therefore they did not collect any toll. Now, this is a classic example of a change in law. This is an enactment. This is to bringing into sort of context a law which was not there at the time the contracts were entered into. This has an impact on the contract itself by way of making the contract more expensive to perform, in the sense that you did not have revenues for a certain period of time, and therefore you were entitled to change in law relief, which basically meant you had to be compensated for the time period during which you could not collect toll, and that was sort of the number of days multiplied by the sort of average toll that you would have collected in those days. The Supreme Court of India has recently uh, this was a couple of years ago in Energy Watchdog versus CRC, and anyone interested in both topics, both force majeure and change in law, should read this judgment. It's a very well written judgment, and particularly on force majeure, it provides a lot of detailed analysis of the sort of the jurisprudence and the position under Indian law. But in that case, what is pertinent is that the Supreme Court recognized change in law clauses. It says these are enforceable clauses, and the purpose of a change in law clause is that you put the affected party back to the same economic position as the affected party was if the change in law had not occurred. In a sense, it is like a restitution or an indemnity clause, which allows you to sort of recoup the economic losses that you suffered as a result of a new law. Uh, I think that sort of brings me to the end of my presentation. I think what we have tried to cover is force majeure. We have tried to cover frustration and impossibility of contract, and we have tried to cover change in law. Uh, and I would happily sort of take questions now.
Yes, so now we would like to move on to the questions, and I would request all the participants to please post any questions or doubts if they have any.
Just give me
So,
a second. I need to switch on the light here.
yes, sir. Okay, please take your time.
All right.
So, shall we begin?
Yes.
Okay, sir. So, sir, first question comes here is that can a party still be sued if a qualifying event occurs? Proper notice is given and mitigation as well.
Can a party still be sued if if there is an event and effectively what we are saying is that uh, I mean, of course, I mean, if you take sued in the sort of the general context of someone bringing a legal action against you, yes, anyone can. It's nobody can, as sort of as we would know, nobody can be denied their legal remedies. Now, the question is, I think the question more sort of pertains to whether the party is still liable, and I would say that would depend on sort of the nature of the event and the actions which were taken by the party. If the party can sort of fit it into the definition of force majeure, and the party can also establish that it had followed all the procedural requirements necessary for that force majeure claim to be sustained, then they would succeed.
Yes, sir. So actually, I cannot see more questions though, and I believe that you have very well addressed the entire session for us. It was a
Uh,
really enriching session, and I myself have learned so many things about frustration, how you draw the differences between the colonial law and everything, and how it actually agrees and everything. It was a really enriching session, and I actually look
So
forward
I
to
think
hosting.
what we can do is perhaps
Yes,
if you are thinking of sending the presentation to the participants, uh,
absolutely, sir. We
you
can
can
do
do
that.
that, and then from that perspective, if there are people who are either watching here or on YouTube who
Yes,
wants to send in questions, they can sort of send it by email, and we can.
absolutely, sir. We can do this.
Uh,
Yes, sir. Of course, sir.
okay. Thank you very much, everyone.
Thank you so much, sir, for taking out time for this session.
Not at
It
all.
was a really good session for us, and we actually look forward to hosting more sessions with you. Thank you so much for your time, sir.